This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today I'd like to talk about a truly egregious misuse of medical treatment and the law surrounding people who suffer from mental disorders. In this case, hospitals were imprisoning patients for profit, and the patients eventually found themselves released and filed a Racketeer Influenced and Corrupt Organization, or RICO, action against the doctors and hospitals who had imprisoned them. And they not only received damages, but also sought disgorgement, which is a type of control of damages akin to exemplary damages. In the case of Diane Creel and Lynn Creel versus Dr. Says LLC et al., a September 27, 2022 decision of the United States District Court for the Eastern District of Texas, plaintiffs obtained a verdict against defendants Dr. Yupo Jesse Chang, MD, Reliance, Inc., Universal Physicians, PA, Dr. Says LLC, Office Winsome LLC, and Yung Husan Yao, a.k.a. Angela Yao, for violations of the Civil Racketeer Influenced and Corrupt Organization Act and RICO conspiracy. The court, after the verdict, found it needed to enter its findings of fact and conclusions of law regarding equitable disgorgement. The findings of fact were simple and clear-cut. Plaintiff Lynn Creel accompanied his wife, Plaintiff Diane Creel, to the Behavioral Hospital of Bellaire in August of 2017. The Creels arrived at BHB planning to receive information on the hospital's advertised outpatient group, women-centric grief counseling. Upon the nurse's return, after an initial interview, the Creels advised that they were leaving because they did not like the treatment plans that BHB had offered. The nurse informed the Creels that they were not allowed to leave because BHB had filed an emergency warrant for Diane's detention, and Diane would be placed under a 72-hour hold. The Creels then realized that BHB medical staff had locked both the door out the front of the building and the door to the intake room. Diane was taken to the psychiatric unit against her will. BHB did not permit Lynn to visit Diane in person. In all this time, neither Lynn nor Diane ever saw the warrant for her detainment or even a shred of paperwork. The defendant's scheme underlying the Creel's experience began with the business activity of Dr. Yupo Jesse Chang, a family physician who has spent much of his career managing other medical practices. As Chang's only notary, Yao kept a detailed notary book. The physician recommending commitment of a patient signed off on the notarized documents, but the physician was never physically in front of Yao, the notary, when he or she signed the document. The notary documents reveal that in just 3 days, between August 6 and August 10, 2017, a psychiatrist employed by BHB signed applications for involuntary commitment of 12 different patients. 12 plaintiffs sued 22 defendants, alleging various causes of action based on their involuntary confinement and stay at BHB. The jury found the defendants were employed or associated with a RICO enterprise, had participated either directly or indirectly in the conduct of the affairs of the enterprise, and had participated through a pattern of racketeering activity. The jury assessed plaintiffs' compensatory damages at $300,000. The jury also found that all defendants conspired together to violate RICO. The jury awarded Diane damages in the amounts of $75,000 for physical pain and mental anguish sustained in the past, $50,000 for physical pain and mental anguish in reasonable probability Diane will sustain in the future, $85,500 for loss of earning capacity sustained in the past, $104,000 for loss of earning capacity that in reasonable probability Diane will sustain in the future, $15,000 for medical care expenses incurred in the past, and $50,000 for medical care expenses that in a reasonable probability Diane will incur in the future. Specifically, the court upheld the jury's verdict against defendants for violations of RICO and is now dealing with the issue of equitable disgorgement. Plaintiffs have long pleaded and disclosed a claim for equitable disgorgement in this case. The evidence attributable to equitable disgorgement mostly involves the medical documents that Yao falsely notarized. In January of 2017 alone, there were 276 documented applications for involuntary patient commitments sent through one of Chang's companies. Defendants produced no evidence to suggest that they would change their activities following the lawsuit. Despite having had to pay back Medicare and private insurance companies for improper billings, Chang was still conducting his business affairs in the same manner. The jury awarded $1,320,500 in equitable disgorgement. A claim for disgorgement under the civil RICO statute is an equitable remedy. The jury's finding on equitable disgorgement under civil RICO is an advisory opinion. The equitable nature of disgorgement requires a court to enter findings of fact and conclusions of law for any amount of the award to stand. Disgorgement of ill-gotten gains is closely analogous to the equitable remedy of exemplary damages, as the principal purpose is not simply to punish the offending parties for having conspired to make the illicit profits, but to convey a strong message to the conspiracies and to third parties alike that there is yet another disincentive to engaging in such prescribed conduct. The court found that the disgorgement in this case was properly sought to prevent and restrain defendants from continuing the unlawful conduct. The conduct that led to the lawsuit was egregious. In my opinion, it was evil. As previously discussed, in calendar year 2017 alone, hospitals that had contracted with Chang filed 3,955 applications to hold human beings in psychiatric hospitals against their will. Chang and Yao were aware of this egregious activity and that it was unlawful. An award of disgorgement of defendants' ill-gotten gains will serve to prevent and restrain future illegal conduct. Moreover, the court found that the jury awarded disgorgement for the purpose of preventing and restraining defendants' future conduct. The court then calculated disgorgement and what it found to be sufficient, and awarded an amount of disgorgement of $296,625, being a calculation of $75 of profit times the 3,955 acts of imprisonment. Plaintiffs presented no evidence of any other profits derived by defendants through unlawful conduct that violated RICO, which would support a greater award of disgorgement. In my opinion, the conduct of BHB and the physicians and nurses involved in this scheme were egregious to the point of being evil, and under the law, using a legal format to kidnap patients for profit. The disgorgement was a needed addition to the RICO damages to deter future conduct. And since these scofflaws billed Medicare and insurers for the alleged treatment, even if it repaid the insurers and the government what they had stolen, they were perpetrating a fraud that was proved beyond a preponderance of the evidence. And since, as the court explained, the defendants are still confining people against their will, the court should have referred the defendants to the Department of Justice for prosecution. I sincerely hope that they did. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the website zalma.com/blog. And you should subscribe so that you learn of every blog posting and every new video. And if you found this video to be interesting and educational to you, please advise your colleagues and friends so that they can also view the video, read the blog posting, and subscribe to my blog, my locals community, and my Substack publications. Thank you for your attention.